All right, welcome back. We're going to talk about the steps in a criminal jury trial. I'm going to just recommend that you use this great graphic that you have here, and I'll quickly go through how this works. So once the jury members have been selected, the judge swears them in and the trial itself can begin. In actuality, it's difficult to predict how a jury will go about reaching a decision. There are many studies on this question, but there really hasn't been any definitive, consistent patterns of jury behavior. So we start with opening statements. Attorneys have the choice to do that or not. Most do. And the attorneys are going to give a brief version of the facts and the supporting evidence that they will present during the trial. Evidence is anything that's used to prove the existence or non-existence of a fact. So for the most part, evidence is broken down into the following categories: testimony and real evidence. And testimony consists of statements by competent witnesses, and real evidence is evidence that's brought into court and seen by the jury. And there are rules of evidence that have to be followed, and things have to be relevant, reliable, and not unfair, prejudicial, or giving prejudicial, can't think of the word, prejudice against the defendant with the evidence that's presented. So there's different types of testimonial evidence. There is direct evidence, and then also circumstantial evidence. I'm sure you've heard of a case that is purely based on circumstantial evidence. And so, of course, direct evidence is much better. That's definitely evidence that's been witnessed by a person giving the testimony. And so that always makes a prosecutor feel much more confident about his case when there is direct evidence. Although there's been guilty convictions, many in just circumstantial evidence. So relevance, when we're talking about relevant evidence, we're talking about evidence that tends to prove or disprove a fact in question. So forensic proof that the bullets found in a victim's body were fired from a gun discovered in the suspect's pocket at the time of arrest is certainly relevant. And evidence also may be excluded if it would tend to distract the jury from the main issues of the case, or maybe mislead the jury, or cause jurors to decide the issue on an emotional basis. I want to talk a little bit about defense attorneys, and they are likely to have some success precluding prosecutors from using prior purported criminal activities or actual convictions to show the defendant has criminal propensities or an evil character. So concerns of this kind are codified in the federal rules of evidence, which state that evidence of other crimes, wrongs, or acts is not admissible. So basically what that means is we can't use a defendant's criminal history in their current trial. And that can be really damning evidence. If someone has a history of convictions of certain crimes and now they are being prosecuted for another crime that's very similar. So that's an important piece that is inadmissible in court, not admissible. So there's direct examination and cross-examination. I'm sure that you guys at some point have watched law shows that talk about this, so that goes through different types of steps in a criminal trial. But the prosecutor attempts to establish guilt beyond a reasonable doubt by presenting corpus delicti. And corpus delicti is a legal term, and it refers to the substantial facts that show a crime has been committed. And then there's direct examination of a witness. So the prosecutor calls witnesses to the stand, asks them questions pertaining to the sequence of events, and also talks about, what's being addressed during the trial. And that form of questioning, that's known as direct examination. So when we talk about the competence and reliability of witnesses, that's a huge thing. And witnesses must have sufficient mental competence to understand the significance of testifying under oath. And they must also be reliable in the sense that they're able to give a clear and sound description of the events. So the Sixth Amendment states in all criminal prosecutions, the accused shall enjoy the right to be confronted with witnesses against him. And this confrontation clause gives the accused, through his or her attorneys, the right to cross-examine witnesses. And cross-examination refers to the questioning of an opposing witness during trial. Both sides are allowed to do this. And this cross-examination allows attorneys to test the truthfulness of opposing witnesses. And so they can go back and forth, redirect, recross examination. So this questioning back and forth can go on for quite some time in a case. Attorneys should know about is hearsay, and hearsay can be defined as any testimony that's given about a statement made by someone else. And there are a number of exceptions to the hearsay rule, and as a result, a good deal of hearsay evidence definitely finds its way into criminal trials. But the logic behind this exception is that a person generally does not make a statement against his or her best interest unless it's true. So the defense has a number of strategies that they may or may not use throughout a case, but we know that they definitely want to create that reasonable doubt. They are most commonly defending their clients by attempting to expose weaknesses in the prosecutor's case. And even if the prosecution can present seemingly strong evidence, a defense attorney may succeed by creating reasonable doubts. And the defense can choose among a number of other strategies to generate reasonable doubt in the juror's mind. It can present alibis or affirmative defense, and that is facts that add to ones offered by the prosecution. So possible affirmative defenses might include self-defense, insanity, duress, entrapment. And with these affirmative defenses, the defense attempts to prove that the defendant should not be found guilty because of these circumstances. So there's rebuttal and surbuttal, and that is the process of when the defense closes a case, the prosecution's permitted to bring new evidence. And it can be evidence that was not used during its initial presentation to the jury. This is called the rebuttal stage. And when this rebuttal stage is finished, the defense is then given the opportunity to cross-examine the prosecution's new witnesses and also maybe introduce new witnesses. And then we have the final act, which is the surbuttal. And after these stages have been completed, the defense may offer a motion for a directed verdict. And that's basically just asking the judge to find in the defendant's favor. Oftentimes that motion will be rejected. It almost always is. And then the case would be closed at that point, but that doesn't happen very often. And then next, of course, we have closing arguments. And that is where the attorneys summarize their cases. You know, imagine if a trial goes on for months and months. It's nice to have closing arguments because it's really going to wrap things up into a nice and tight package for the jury. In most states, the defense attorney goes first and then the prosecutor. So it's going to be used to basically summarize everything, but then it can also emphasize shortcomings in the opposing party's case. And then what happens at the end of the trial? So before the jurors can begin their deliberations, the judge gives the jury a charge, and that basically sums up the case by the judge. And it instructs the jurors on the rules of the law that apply to the issues in the case. And these are called charges, but they can also be considered jury instructions. And they're prepared during a special charging conference with the judge and the trial attorneys. It's important that they do this correctly. If it's not done correctly, it's something that could come back on appeal. Then the jury goes in and starts their deliberation. It's a somewhat mysterious place. It happens in complete seclusion. They are not allowed to talk about it. They are not allowed to appear in public. It's called the jury being sequestered or isolated, especially when there is supposed to be, a long period of deliberation. Next, of course, we have the verdict, and that's really the formal decision, when the formal decision of the case comes out. And the most common ones, of course, are guilty and not guilty. And there can be different degrees of guilt that can come from that. And following the announcement of guilty or not guilty, the jurors are discharged and the jury part is finished. And when a jury is unable to agree on a unanimous verdict, a majority in some states, but usually it's, I think it's usually unanimous, that's called as a hung jury. And following a hung jury, the judge declares a mistrial, and the case is tried again in front of a different jury if the prosecution decides to pursue that matter. In some states, if there's only a few dissenters to the majority view, a judge can send the jury back to the jury room under a set of rules set forth more than a century ago in Allen v. United States. And the Allen charge, as this instruction is called, asks the juries in the minority to reconsider the majority opinion. Of course, appeals can happen after the verdict is given. Appeal is only available to the defense, and if a defendant loses this case in a trial court, he cannot automatically appeal it. He must first be able to show that the trial court acted improperly on a question of law. And common reasons for appeals include, introduction of tainted evidence or faulty jury instructions, things such as this. Double jeopardy, let's talk about that. Double jeopardy is part of the Fifth Amendment that basically says that you cannot appeal, you cannot be charged multiple times for the same offense. So if a jury finds the accused not guilty, the prosecution cannot appeal to have the decision reversed. And to do so would really infringe upon those Fifth Amendment rights against multiple trials for the same offense. And this guarantee against being tried a second time for the same crime is known as a protection from double jeopardy. And this prohibition against double jeopardy means that once a criminal defendant is found not guilty of a particular crime, the government may not re-indict the person and retry him for the crime, the same crime. The prohibition against double jeopardy is not absolute. There are several circumstances in which, for many different reasons, a defendant can find herself or himself back in court after a jury has failed to find him or her guilty. There's always loopholes that can be found. Of course, there's many steps in the appeal process. There's two basic reasons. The first is to correct an error made from the initial trial, and the second is to review policy. And the method of filing appeal differs among the states, but the defendant has to file a notice of appeal, and this is just a statement outlining the basis of the appeal. And then both parties file briefs, and that is a written document, written legal document. Then attorneys from both sides have an opportunity to present oral arguments to the appellate courts, and then the judges of the appellate court retire to deliberate the case. And the slides go through all of these circumstances. So wrongful convictions, I'm going to really encourage you guys to take a look at some different websites that talk about certain attorney firms that do these wrongful conviction cases. They're really interesting. But in 2009, the United States Supreme Court ruled that convicts have no constitutional right to DNA testing that may prove their innocence. So nonetheless, most states allow prisoners access to such testing if there is a possibility of a wrongful conviction. So I think it's called the Justice Project has a website that talks about this. So even after the appeals process is exhausted, a it says a convict in my notes. I don't know that I like that term, but a defendant who has been convicted, has a conviction, which I guess would be a convict, may have access to a procedure known as habeas corpus. And this stands for "you have the body" in Latin. And this is a judicial order that commands a corrections official to bring a prisoner before a federal court so the court can hear the convict's claim that he or she is being held illegally. And a writ of habeas corpus differs from an appeal in that it can be filed only by someone who is imprisoned already. And we have seen a lot of individuals be released on habeas corpus DNA. I think it's the Justice Project is the name of that website. Long chapter, guys, and I went through a lot, but please know that this really breaks it down step by step. And I mean, you could watch one Law and Order show and see many of these different steps, or other crime show or court show. Have a great night.